Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Please be seated. I'll now call our first case on the docket, AP-77 113, in re Shirley Dixon. Is Miss Dixon in attendance? Hearing no answer and seeing no indication that she is in attendance as ordered, we will then move on to our, for the moment, to our second case on the docket, number AP-77098, Lucky Ward versus the State of Texas. Would counsel please approach the bench? We will hear first from counsel for the appellant, and we would ask that you identify yourself by name so the recording of this hearing will be easier to track if you'd be so kind, both of you.
Yes, Your Honor.
All right. You may proceed.
Mr. Presiding Judge, may it please the court, my name is Gretchen Sween, and I represent Appellant Lucky Ward. Mr. Ward was convicted and sentenced to death in Harris County in March of 2020. This was nearly 10 years after his arrest, at which time he confessed as a mentally ill homeless individual to having caused the death of his friend, another homeless individual, Rita Long. That confession was captured on videotape in the police station, but the state relied on its theory of capital murder on Texas Penal Code 1903A7B, which requires proof of two different murders in two different transactions involving the same scheme or course of conduct, which this court has had some recent familiarity.
The statute is a little broader than that, though, isn't it? I mean, it allows conviction upon demonstration of multiple murders, right? Not just two.
Correct, Your Honor. It can be more than one is the burden of the state, but there must be, when they're not part of the same criminal transaction, they have to prove this same scheme or course of conduct. And it is our position that they did not even articulate a legally cognizable common scheme, nor did they adduce legally sufficient evidence of the second murder that was the charged offense, the murder of Carlos Rodriguez, a transgender individual who was found dead in his home following or during a sexual interaction. So there were two murders, one to which Mr. Ward had confessed and which provided the state all the information they needed to obtain a conviction, and then one he vehemently denied having any role in, although he also volunteered to the police that why his picture was on the camera of Rodriguez, which was found in Rodriguez's.
What is the issue? What are you arguing here? I mean, how many issues are there in this case, and what are you arguing?
This is an excellent question, Your Honor, and I appreciate the chance to pivot. Okay. Part of the problem here is this case is so larded up with error, it was very difficult to designate issues that I would like to discuss in the limited time I have, but that is irresponsible. So I will quickly say I'd like to start with points of error 10 through 22, which involve Mr. Ward's competency to be tried. Even though it took 10 years for the state to come up with evidence. And
that's kind of why I asked. I'm like,
yes,
you're telling me all this stuff about different reducing things, but it seems like competency is
But there's this paradox here that I'm suggesting there was a rush to trial when Mr. Ward was showing overwhelming signs of incompetence. But part of this delay was this effort to find evidence to support a theory, as opposed to evidence leading to a theory. So Mr. Ward showed overwhelming signs, really throughout this 10-year period, that he was a person with serious mental illness, well documented. He was a guy that MHMR had designated as disabled because of his mental health issues. He had a monthly disability check. Lots of evidence of mental illness, yet he was never properly assessed for competency. He was excluded from most substantive pretrial hearings because of comments made about how he wasn't capable of being there. And he was excluded from a chunk of voir dire, which is against statutory law. And he was excluded from much of his trial, not because of a voluntary waiver, but because he was showing these flagrant signs he was incompetent, and there was a reluctance on the part of the court to pause and figure out what was going on. And as Your Honor is very aware, we have this wonderful statute, Chapter 46B, that the legislature took great pains to craft after years of recognizing there's a real problem in the criminal justice system of mentally ill people being tried while incompetent, and that judges and lawyers aren't necessarily trained to recognize the complexity of mental health issues that interfere with their ability to rationally engage with counsel and to comport with social norms that are expected in the courtroom. So we have this great statute, and I've provided Exhibit 1 to the oral argument, which includes a flow chart that appears in bench books provided to judges to help them, because this law was seen as so innovative, but it's, again, not intuitive. It requires, it's mandatory, that once you see suggestions of competency, you stay whatever the proceedings are and then follow the flow chart. Here, as outlined in points of error 10 through 22, virtually nothing about the statute was honored. We have Mr. Ward coming unhinged during voir dire.
I want to
Yes.
slow you down a little bit. You mentioned this flow chart is an exhibit, and so to some degree, is that in the statute itself, the flow chart? Or is that something that someone else created in order to help other people to understand how the statute should work?
Judge Geary, it's the latter.
Okay.
And as we noted in a filing, there was an objection to the exhibits, that this is not part of the statute. It is a demonstrative exhibit of the statute that is prepared for a bench book.
Do we know, like, who prepared that, or is that?
This one is from the 2019 version of the Texas bench book on mental illness. And in my filing, I said it's,
Is that
it-
right? Prepared for trial court judges to follow?
yes, Your Honor. And I believe that the Honorable General Counsel,
Judges,
I'm sorry,
by other judges presumably.
I'm sorry.
The bench book is drafted by whom? It's not subject to bicameralism and presentment. It is not approved by the House, the Senate, and signed off by the governor, correct?
That is correct, Your Honor, but for instance, a member of the General Counsel of this court was on the committee that prepared the bench book, the most recent version published in
And I'm
2021, which
sure
has the
I'm
idea.
sure it's very well written, but the question that's coming to you from someone is going to be, would departing from it violate the law?
And Your Honor, I would say yes, because the statute is replete with mandatory language, shall, must. And as this court, in a unanimous decision in another death penalty case of Damon Blunson, made clear, once there is some evidence, and that is a low bar, one must stay the proceedings and follow the statutory guidelines, which include, once there is some evidence, and one is only allowed to consider evidence of incompetency, not competency, then there must be appropriately appointed experts to do an exam per the statutory guidelines. You have to have 30 days minimum to review collateral sources, do the assessment, provide a report. None of this stuff happened. You had,
competency hearing before the trial started?
Your Honor, there was, in the middle of voir dire, when the client,
Not before that, before the trial, was there any type of competency hearing requested before the trial started?
no. What is bizarre is in the record, there are a couple of, in the clerk's record, a couple of these forms suggesting that a magistrate requested a mental health evaluation, but there's no record it ever happened, no report as mandated by law. What we have over the years are lots of comments on the record about Lucky Ward's mental health, about, for instance, him thinking he's being poisoned and losing a lot of weight. He himself, the few times he was allowed to come to court, talks
My
about.
question is, at what point was there ever a competency hearing for this defendant?
It's our position, there never was. There was no competency.
hearing?
There was a
That's the
hearing.
position. Was there a hearing where a judge presided over a hearing and made a finding that he was competent or incompetent?
What happened, Your Honor, is that
Yes
during
or no?
voir dire,
Okay.
there was a meltdown, and counsel asked the judge, begged the judge to stop. Their client attempted suicide in the holdover cell. Things had gone crazy. They said they could not rationally communicate with him. And the judge, and this is important to recognize, had been brought in to cover voir dire. She had not been a part of this case for the 9 years before. She says on the record, it's not uncommon, and especially here where you had a judge who had been elected and had no known criminal law experience. And so she was going to, this experienced judge, come in to cover voir dire. She makes comments about prior competency evaluations. And the defense says, we're not aware of any. Because in fact, there weren't. There was never a time. There were suggestions of incompetency made in documents, in court records, but no evaluation. When she finally is told, you're about to inject error into this case under Turner, if you don't pause, she stops voir dire, but Lucky Ward is not there, then continues to interview jurors outside his presence, but then appoints, this is Friday,
Like,
a judge, a psychiatrist.
She continued jury selection
Yes.
with the defendant removed?
Yes, she did. After he'd been removed, she continues to hear excuses. She doesn't do individual voir dire. But part of what is in Exhibit 2 is a demonstrative of all the known times Lucky Ward was not present and there was no voluntary waiver. And that includes parts of voir dire. And I've had some, there's differences in our briefing about how many jurors were excused.
So we deviated, getting back to my original
Yes.
question. Was there ever a competency hearing at any point before or during the trial?
During voir dire, there was this pseudo drive-by competency hearing where over the weekend, she sent in a conflicted expert who admitted on Monday morning he'd not yet reviewed records. He'd just been given some records from the jail that morning. He had never met with Lucky Ward, but he was willing to say he was competent based on talking to some jailers. That was it. There was no examination by the defense or even the state. Meanwhile, the defense had also obtained funding to get their own expert appointed. And he had not yet, he was not able to appear in person. He asked to appear telephonically. The judge denied it.
Because I've participated in several competency hearings. You stop the proceedings, there's a judge, whether it's the trial judge or another judge is referred to him. There are witnesses that testify, and after it concludes, then there's a finding of either competency or incompetency. Did that ever occur in this case?
What Judge Bradley concluded, after there was one witness, the witness who never met with Lucky Ward, and then the defense was not able to put on their expert because he had not either had a chance to meet with Lucky Ward. So on Monday morning, she asked the defense, are you willing to proceed? And they say, well, we are, essentially waiving the competency inquiry. And then she pushes them to say, well, do you think he's competent? And they say, they sort of talk around the issue, but they say he's competent to decide not to testify. And then they put on the record a whole bunch more evidence he's not really competent during the course of that day. He's not there in the morning proceeding, and then they bring him back at some point, and he's drugged so much, they put on the record that he's falling asleep and he's not able to talk to them.
I guess the answer is no, right?
The answer is no. It's just, Your Honor, and I apologize for all the complexity. I think Judge Bradley believed she had made a finding of competency, but there was never really a full hearing, let alone the formal trial that the statute mandates, as this court recognized in Blunson, that once you acknowledge there's some evidence and you appoint a psychiatrist or psychologist or a mental health professional who's qualified, once you make that admission, you have to follow the statute, mandatory that you end up with a trial unless both parties agree that the defendant is incompetent. And that process was not filed, and it's mandatory. And back to your question, Judge Hank, this all stems from decades-old Supreme Court law that says there is a substantive constitutional right not to be tried while incompetent. And the reason is because there is a fundamental right to be present and confront those who accuse you. And if you are mentally incompetent, you're being deprived of your right to be present. So this goes back to Dusky, Pate versus Robinson. And what the Supreme Court dictated to states is you need to come up with adequate and fair procedures, due process, to protect this substantive federal right. And Texas's solution to that is Chapter 46B, and quite the admirable state law that shows judges what is mandatory to protect due process. So Mr. Ward didn't get that. He didn't get the due process, and therefore we have no way of knowing if this substantive right not to be tried while incompetent was robbed. But we have a lot of good evidence because he missed most of his death penalty trial.
We did have a question, though, as you pointed out a minute ago, to his counsel from the bench of, is he competent? And the answer, the judge asked his counsel, is he competent? And the answer she gave was yes, right? So what's triggered as against that backdrop? I understand the chart and best practices are to follow the chart, but what's a judge to do when the judge asks the right question and gets the answer from his counsel that he is in fact competent?
Two things, Your Honor. First, we look back to Drope, one of those seminal Supreme Court cases on competency. And in Drope, the Supreme Court makes clear that while you need to rely on counsel to inform you as a judge, you do not abdicate your responsibility as a judge ever to ensure the defendant is competent. And that's why in Drope, we had a similar situation of the defendant attempting suicide during trial. And the argument was, well, he brought it on himself. So too bad, so sad. Supreme Court rejected that. Also, this court in Blunson rejected that implicitly, because in Blunson, same thing happened. The counsel are like, never mind, we take it back. We feel he's competent. We can go ahead with trial. And this court said, no, the statute means what it says. And so judges do not have any discretion to simply ignore the statute that took years and a lot of bipartisan and interdisciplinary work to craft. And I see I'm about out of time, and I never got to 404B. I want to say real quickly that I know Judge Keel is very aware of the analytical process because of Velades that you decided in 2022. Three-prong analysis. None of those were satisfied in this case. There was not, beyond a reasonable doubt, proof that Lucky Ward had anything to do with Carol Flood's murder. There was also no need on the part of the state that is legitimate unless you overrule virtually all of this court's 404B jurisprudence, because identity of a perpetrator, using an extraneous to prove that, requires nearly identical fact patterns. We don't have that with Rodriguez and Flood.
Where's the harm there? It's happening in guilt innocence, right? The evidence is coming in. It is odd to me that you would have an unadjudicated prior bad act with something potentially less than preponderance of evidence tying this defendant to that act. So the harm for the other two, frankly, to me seems fairly low in terms of guilt or innocence, but there's a high risk that that error, if it's error, washes over into the punishment phase, where you have an unadjudicated, unproved additional murder, potentially, that was put in front of the jurors during the guilt innocence phase.
And Your Honor, if I
Where's
may,
the
I think
harm?
I'm
Go
out
ahead,
of time, if I may respond.
Yeah.
I think the harm is actually far greater in guilt innocence because there was such insignificant circumstantial evidence linking Mr. Ward to Rodriguez, and then virtually no competent evidence, really none, that he was responsible for Carol Flood. So by injecting that, you blind the jury, and as this court said in Ridgely, an extraneous murder in the guilt phase, the prejudice is almost self-evident. It certainly had very little probative value. Carol Flood's tragic demise doesn't get you any closer to proving who killed Carlos Rodriguez, because there's nothing in common in the two crimes.
Before you go, what do you see as the threshold, let's say a conditional relevance threshold under 404B to get evidence of the other strangulation because of the fact that he'd given her the scarf, to make it probative of anything related to the other murders? at a minimum, does there have to be proof by a preponderance that he did the unadjudicated, uncharged murders? Does it have to get to that level before it should be admissible? to
What
prove
you're-
Common scheme or technique?
What this court has said over and over is there must be proof beyond a reasonable doubt of the extraneous. So that's, first you gotta prove that. They did not satisfy that, and there's been a lot of loose language about DNA in this case. There was not DNA, there was YSTR results from a mixture involving at least 3 people, including 2 males. How you even do YSTR testing when you have 2 males, I don't know. But that was what they had on a scarf that had multiple people's DNA all over it. It was a scarf a homeless woman had, who knows where she found it, it's found in the streets of Houston. I'm telling you, I touched this podium, I may leave my DNA here. Opposing counsel comes up, touches the podium, she may take my DNA and then go back to Houston in her car, leave my DNA on the steering wheel mixed with that and her kids and whatever. That doesn't prove I was in her car. The scarf is not dispositive of anything, and plus there was multiple DNA on that scarf, multiple people, in a community of homeless people where Lucky Ward plainly, he was sleeping in the streets, as was Carol Flood, going to the same shelters. It's not at all proof of guilt of a
There
murder.
are a lot of also a lot of similarities between these. I mean, sort of similar time frames, similar places, similar manner of death. A lot of other like sexual things going on right around the time of death. So there's a lot of beyond the DNA, right? There's a lot of other facts that seem to connect these murders.
And Judge Erie, we would respectfully disagree in that if you look at the facts, and there's a summary in a demonstrative Exhibit 3 of the basic factors of the Rodriguez case and the Carol Flood case. The only similarities, and the state really had to stretch a trial and talk about strangulation in Houston. Like this isn't sufficient, this isn't what is in this court's 404B cases.
I mean,
They're signature crimes.
What is the full time frame from the earliest murder to the latest murder?
Mr. Rodriguez died on September 15th, I believe, and Rita Long, September 30th, and Carol Flood was, I think, October 10th.
So, I
But
mean,
in-
it's like this is less than a 2-month period of time. I mean, less than a 2-month period of time, you have all these strangulation murders. How many strangulation murders happen in a year
Well, and
in
this-
that same area of town? I'm curious. I don't know.
And Your Honor, that is an excellent point, and one of our other points of error, clearly not designated for today, is about how the defense was deprived of a chance to put on that very evidence. They had obtained a spreadsheet from the Houston Crime Lab of all the strangulation deaths in the Houston area over this period, including all the years Lucky Ward spent in jail, and there are numerous ones. And if you start reading the 404B cases out of this, you find strangulation is not an uncommon, unfortunately, way for someone to die.
Counsel, quickly, very quickly. Why would these be generic instead of signature?
Your Honor, in the CCA case law, if you look at them, it's like even having the semen of a perpetrator in a victim in 2 different crimes has been seen as insignificantly similar. Even when these were both women who were assaulted in the same town and in the same, the person broke in at the same time.
But in this case,
in
why
this
would you
case-
say they're generic instead of signature?
Because Mr. Rodriguez died, we know, of strangulation, and the autopsy report suggests it was neck compression, because there was very little trauma to the neck. There were some red spots on his neck when his naked body was found. After his roommate reported he had had a sexual encounter with a bald, muscular black man. Miss Flood was a 60-year-old African-American homeless woman who died from ligature strangulation with a lot of violence. There was trauma to her head, there was trauma to her vagina, was half naked, very different crimes. This is not signature handiwork Mark of Zorro, the kind of language this court has utilized in these identity cases where 404B has been seen as appropriate.
Okay, counsel, I think we have that argument. You have some time for rebuttal. We'll look forward to
Okay,
hearing.
so sorry, Your Honor. Thank you very much.
Good morning, and may it please the court. My name is Patricia McLean with the Harris County District Attorney's Office, and I represent the state in this case. I'm going to jump right to the extraneous issue since that's the last topic you all covered. The trial court did not abuse its discretion in admitting evidence of Carol Flood's murder in the guilt phase under Rule 404B and 403, but the focus, since y'all focused on 404B, I'll start there. First, the trial court properly did find that any rational jury could find that appellant murdered Flood beyond a reasonable doubt. And to Your Honor's question, that is the standard. Is the question that the reviewing court asks is, yes.
When you said that this could be beyond a reasonable doubt,
Yes.
okay? Are you saying that some jury may do it? Are you saying that this is really evidence beyond a reasonable doubt? Because I can't see that.
Yes, Your Honor. I'm saying both. The standard for review, as you all know, admitting an extraneous is under an abusive discretion standard in the first place, so there is some deference to the trial court's findings on this. And the necessary question is, would a rational jury have necessarily entertained reasonable doubt in finding appellant murdered Ms. Flood? And that's not the case here.
Is it any rational jury or just a rational jury? Because a lot of juries aren't really rational.
The standard, Your Honor, is any rational jury, Your Honor.
Well, what, we need to review that, and what was there to support that conclusion that we can cite in our opinion if we were to agree with it?
Yes, Your Honor. First, which y'all touched on earlier, the DNA mixture on the scarf. Mr. Ward cannot be excluded as a possible contributor to YSTR DNA mixture on the scarf. And it's important.
Didn't he give her the scarf?
He actually, that's one of my other points, Your Honor. He, at first, when Officer Cisneros was interviewing him, appellant said he didn't know Carol Flood, he didn't know anything about this, he didn't remember anything about it, didn't know anything. And Cisneros went to go find a better picture of Miss Flood to see if appellant could recognize her, which he was unable to do. When he came back, appellant asked to look at the same picture Cisneros had already showed him, and at that point he admitted, yes, actually I do recognize her, and he admitted that he gave her the scarf at some point. And back to the DNA.
And counsel, how many days did the state spend telling the jury about this extraneous murder?
There was one full day of testimony, and then the following day, Officer Cisneros, there was brief testimony from him about appellant's confession, or his interview about Flood's death, and also he also testified about the similarities between all three of the cases. So a little over a day.
At least one full day and part of another.
Yes.
Okay.
Out of a 7-day trial, yes, Your Honor.
Yeah, and when you say a 7-day trial, that's 7 actual days. So you're saying there was 5 days of testimony that wasn't related to this extraneous murder?
I'm saying there's more than 5 days. That's unrelated. There's 5 and some change, and there was also an extraneous offense hearing an additional day, but that was outside the jury's presence on this case. They had a full hearing to see on the admissibility issue of the extraneous, Your Honor.
And wouldn't you think that spending more than a full day of testimony on an extraneous offense is a little overkill?
No, Your Honor, I disagree. And that, to the 403 point about consuming an inordinate amount of time, this court has held, I believe it was Page or Lane, I apologize, it's in my brief, that essentially spending a little less than 1 day out of a 5-day trial was not an inordinate amount of time to spend on an extraneous. So this was roughly about the same time. It's about 1/5 of the entire trial. It was about 1/5 of the entire record, and much of the evidence, it was the same type of evidence. There's a lot of DNA evidence for all 3 of these victims. And Cisneros and the DNA analyst, Robin Guidry, testified to the instant offenses as well. So there was repetition of, it wasn't all new witnesses, that kind of thing.
And isn't it true that the state waited till the very end of question and answer to get into the extraneous?
Yes, it was after the state presented evidence of Ms. Rodriguez's murder and Ms. Long's murder, and at that point, they moved for the extraneous hearing due to defense counsel's cross-examination and the evidence that they admitted, their own affirmative evidence admitted that raised the issue of identity in the Rodriguez case and lack of accident or mistake in the Long case. And then that's when they had the hearing.
So the very last thing the jury got to hear was this extraneous offense, which was a murder.
Yes, Your Honor, it was another murder. It was prefaced before the jury heard anything. The trial court gave a limiting instruction as to both, as to how it should be applied, that it needed to be found beyond a reasonable doubt, of course, before it could be considered at all, and if so, only for those specific purposes for each of the charged victims. And then that same limiting instruction was given in the jury charge as well.
When you were answering Presiding Judge Shank's question a moment ago, I was gonna try to track what you said, because I think he asked you what evidence would convince us beyond a reasonable doubt, and you began
Yes.
by saying there's some DNA.
Yes.
And beyond that DNA evidence, for whatever value it had, what else was there?
Yes, to get back to that.
Yes, thanks.
Not just that there was DNA that appellant could not be excluded from, but the specific location of where that DNA was. Specifically, it was on the scarf, and it was on a loop that extended from a twisted portion at the back of her neck, which essentially the person who strangled her would most likely be holding that exact spot when he strangled her. So that's an important fact as well.
And it's not certain that that's the defendant's DNA.
No, it's not.
possible.
That's right. And for the YSTR testing, the power of the statistics are different than autosomal testing. However, what the DNA analysts testified to, even for the YSTR analysis, the combination of YSTR profiles was only seen in their reference database about 0.2% of the African American population they had in their reference database, 0.3% in the Asian population in their database, and 0% in any other population in that database. So it was a low number even for the YSTR statistical power, or the results.
And in your opinion, that's proof beyond all reasonable doubt.
No, Your Honor, I'm saying that in conjunction with where the DNA was on the scarf, appellant changed his story about how he didn't know her, and then he later said, well, yes, I did, and he admitted he gave her the scarf. Miss Flood was found in an area near where appellant frequented and where he slept, and he also admitted that he, 5 blocks away where Miss Long was murdered, he admitted that he spent a lot of time with her at that location. However, despite all of that, he told Cisneros that no, he had no idea where the YMCA was, he had no idea where the cross street was, even though it was very near where he frequented, where he slept, and where he spent so much time with Miss Long, where he admitted that.
Counsel, so was there other DNA on the little twisty loop thing you were talking about besides?
It was
Miss Long?
YSTR mixture for
Okay.
the minor component.
So there
And
were
then
there were two other contributors in that? as
No,
well?
just 2 males for the
Okay,
minor.
So presumably Lucky Ward and then another person we don't know.
But,
Okay.
correct.
And then
Yes.
now I kind of want to shift to the competency issue because
Yes.
it doesn't,
Of course.
it doesn't matter, all the rest of this doesn't matter if he's not competent, would you agree?
Correct.
All right, so beyond defense counsel's, I think you two would probably argue about how strong this was, but beyond defense counsel's assertion or belief or whatever you want to call it that Mr. Ward was competent, what is the best evidence that Mr. Ward was competent during his trial?
And that actually goes to your questions earlier. Yes, there was an informal inquiry during the trial. During voir dire, the judge engaged in an informal inquiry, which is the preliminary step when a suggestion of incompetency is raised. That suggestion of incompetency was raised during voir dire. That was the first time a suggestion was
By the
raised.
judge or by the defense?
It was by the defense attorneys. They requested a competency eval in the middle of voir dire after appellant refused to come sit in the courtroom. He was expressing paranoid thoughts. He thought the judge was biased and the prosecutors were coaching the jurors, and he didn't like that there were law students observing. And he wanted to go back to the jail, and when the judge told him, no, sir, you're going to go to the holdover in case he changed his mind, he went there, and that's when he tied a sock around his neck. And at that point, defense counsel came out and moved for a competency eval.
Finish answering this question, and then I have a couple of questions on the competency.
Yes, sir.
plan.
And to get back to that, so after that, the trial court appointed a courts expert, Dr. Mahler, to evaluate appellant, and also granted the defense's request to have their own expert evaluate him. Dr. Mahler, appellant refused to talk to him, but Dr. Mahler testified on the following, a few days later. This occurred on a Thursday, and the testimony happened on a Monday. He testified that he reviewed the most recent medical records for appellant. He talked to the jailers who took care of him, and he reviewed the defense's motion and the other information that they provided to him in making his assessment. And after he testified that he opined that appellant was competent, the judge found him so and proceeded with the general voir dire of the next panel. And after that concluded, the defense's expert evaluated him as well. And the following day, the defense confirmed to the court that, yes, he was also evaluated by his own expert as to competency, and they stated they had no further issues. He has remained competent, and they moved forward.
And how long was he in jail before the trial?
It was almost 10 years. He was arrested in November 2010.
And a lot of things happened during that time that would make a normal person think that this guy has some serious problems. Is that correct?
The main thing that was raised was the motion to withdraw in 2014, so about 6 years before the trial. Former defense counsel Geiser moved to withdraw, and in that motion, at the time, Dr. Mahler, he'd reviewed records, and they had hired him to examine him or to interview him, whatever, as a defense expert.
Mueller reviewed the most recent medical records. He didn't look at all these medical records for the 10 years, did he?
No, he did not. And he doesn't need to, essentially, because the question, the relevant inquiry for competency is your status at the time of trial. So lengthy history, it's not as relevant as the 3 months before, which is what Dr. Mahler did review and consider. So that's the question, is at the time of trial.
He didn't actually see the defendant. He didn't go see him at all, did he?
No, he tried for about an hour and a half to talk to the defendant, and the defendant refused to talk to him. But Chapter 46B does not require that a competency eval include an interview with a defendant. And specifically, the statute actually contemplates that there are situations where a defendant will refuse to talk to an expert, as in the statute, I believe it's 46B, it's either .024 or .025, that the expert cannot base his competency determination on the fact that the defendant refused to talk to them. So it certainly contemplates there are defendants who will not cooperate, and there's other ways to conduct an evaluation.
When you're saying that the defendant refused to talk to him, did the defendant sit in front of him and then tell him he's not going to talk to him, or was this second or third hand information from some jailer that said no, he didn't want to talk?
I am not entirely sure how it happened. In the record, he says I think they tried to get him out of his cell to talk to Dr. Mahler for about an hour and a half, I believe is what he testified to, but appellant refused, is my understanding of the record of it.
Counsel, I've got a question for you.
Yes, sir.
If I understand this right, on the shift back to the 404B for me,
Yes, sir.
the state had to show, in terms of between the Rodriguez and the Flores murders, that the modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature. Would you agree with that?
Yes.
All right. Rodriguez was a 35-year-old biological male, and Flood was a 65-year-old biological female. Just addressing those two, how does that create a modus operandi in which the pattern and characteristics of the charged crime and the uncharged misconduct are so distinctively similar that they constitute a signature?
Yes, Your Honor. And in addressing that, it's important to note that while they need to be very distinctively similar, there is no requirement that they be identical in order to be relevant to identity, to start there. Again, this is an abuse of discretion standard, and the question for signature cases or identity cases is whether the pattern and the characteristics are so similar as you stated. And that includes, as this court said in Segundo, the accretion of small, sometimes insignificant details, including the mode of commission of the crime, proximity in time and location, or any other elements.
Would you characterize gender and age as small, insignificant details?
I would characterize them as details, but it's important to note for those two particular details, number one, they're both adults. This isn't an adolescent and a child and an adult. And as for Rodriguez, she was biologically male, but she was a transgender woman. She identified as female, and she held herself out as female, and she even dressed as female, as her friends testified to. And even when Appellant met her, when she took their pictures, she was dressed as a woman. Just to those two specific factors that you were talking about, Your Honor. But in addition, for the signature question, considering things like Appellant's links, as I stated earlier, he frequented the area near where Ms. Flood was found murdered, and it's also where Rodriguez liked to go, the Montrose area where she would go to clubs. And let's see. He also admitted to police that he interacted with both of them. So he had met both of these murder victims before they died. He gave her the scarf at some point, as I stated earlier, and he, again, like Ms. Flood, Appellant cannot be excluded as a contributor to DNA found specifically on Rodriguez's neck.
What's the specificity of that cannot be excluded?
For that one, that was autosomal DNA testing for the Rodriguez case, so the statistics were much, much higher than for the YSTR testing, Your Honor.
Can you honestly say, in your opinion, that this sounds like a signature to you?
Yes, Your Honor. Yes, Your Honor. And the trial court certainly didn't abuse its discretion in finding as much. In addition to the links and the victim characteristics, which I'll get into a little more in just a second, the actual mode of the commission of the crimes is very similar for both of them. Ms. Flood died of ligature strangulation, and Ms. Rodriguez died of strangulation. That was her cause of death. It also included ligature marks, and her death was consistent with ligature strangulation. And multiple witnesses, multiple investigators, and the medical examiner all testified that strangulation homicides are not common. So moving on from there, not only were they both strangled, but they both had fractures to the structures in their necks. They were both found in varying states of undress. Ms. Rodriguez was nude, and Ms. Flood, she was only dressed from the waist up. Sexual activity or assault occurred near in time to both of their deaths.
Oh, wait. Can you direct me in the record where the state introduced any evidence that Flood had recently engaged in sexual activity?
Yes, Your Honor. The medical examiner testified that she had tears to the entrance of her vagina, and he testified that those likely occurred near in time to her death. They were both victims were not found just out in the open. Ms. Rodriguez was found in a duplex that she shared when she stayed there with roommates, and the door was actually left open, so it wasn't left locked and sealed. And Ms. Flood was found next to the YMCA on the stairway that's encased essentially on three sides by a wall and the building itself. So they're not just totally open and exposed to public view.
Were there any similar marks on Rodriguez? I mean, I understand Rodriguez is a biological male, but you seem to put quite a bit of weight on what you referred to as marks around the entrance to the vagina, bruising or tearing. Was there any trauma to the other Rodriguez?
No, Your Honor, but the roommate Sosa testified that when he came down before he left for work, he heard, before he came downstairs, in the hours before Rodriguez was found dead, he heard noises that sounded like oral sex.
So wouldn't that suggest, even under the best of interpretations for the state, that these two dissimilar or similar, one was a rape and one was consensual? Wouldn't that weigh against the state's?
Right, and I'm not suggesting that Rodriguez was sexually assaulted. It's just there's some sort of sexual activity, that consensual or not, that occurred before their death.
Right, but my question is, you put that forward, the state has put that forward as evidence that these two murders are distinctly similar. But if that evidence is interpreted literally, wouldn't it suggest that one was consensual and one was not consensual, weighing against these murders being distinctively similar?
I think it's going to depend on, number one, you still have to look at it through the abuse of discretion lens, and the context is sexual activity, whether consensual or not. And in light of all of the other factors or the other similarities, which also include there were items missing from both crime scenes, the murders happened less than 1 month. Oh, I see my time has expired. May I briefly?
I have a question when you're done, if you don't mind.
May I conclude, Your Honor?
Please, go ahead. He says go ahead.
Okay, thank you. Yes, they both murders occurred about 27 days apart. And both of these victims, the last factor of similarity between the victims themselves is due to their life circumstances, their lifestyles. They were more prone to encounter people that they did not know very well, whether by bringing different partners home, as Rodriguez did, and she didn't have a consistent living situation, and of course, Ms. Flood, who was homeless as well.
So one of the things that is occurring to me is that all of these individuals, and correct me if I'm wrong about this, because I want to know whether I'm wrong about this, but it seems like they all had interactions with the defendant.
Yes.
I mean, there was a confession to killing Long. There's an indication that Rodriguez had interacted
Yes.
with the defendant, and there's also an interaction with Flood, right?
Yes.
Because he admitted that he knew her and maybe gave her a scarf.
He remembered her. He admitted he gave her the scarf at some point. Yes, Your Honor.
So this is just maybe an off-the-wall question. That's just something that I've remained curious about for a very long time, which is, have you ever heard of the doctrine of chances?
Yes, sir, I have.
And so I'm wondering, is that real? Is it something that courts can draw real conclusions from? And if it is true that they could, then what applicability would that have in a case like this? How would we rely upon that, if at all?
Yes, Your Honor. The doctrine of chances, it's very similar essentially to an identity case or an identity issue, because basically the underlying question is, what are the odds that this would happen with the same person and same involvement? Although the doctrine of chances is not specifically in 404B, this court's already stated that it's not an exclusive list. There's other ways that you can get into 404B extraneous evidence. And the few cases I saw in doctrine of chances, it also required a very high degree of similarity to get in. So
we're looking at the same kind of analysis.
essentially, it's the same. They're just so similar. They share so many significant similarities, and it's not a matter of picking one or two at a time. It's looking at everything together, which this court said in Segundo you look at when you're analyzing for a signature analysis.
Thank you very much.
Thank you.
Thank you, Your Honor. If I may start at Segundo, because the state mentioned this case several times. This is a capital murder case in which the primary offense was a rape murder in which the defendant's semen was found in the vagina of the victim, and the extraneous offenses were rapes in which the defendant's semen was found in the victim's. And this court, in a very reasoned decision, was careful about the fact that with this kind of identity use of extraneous, that kind of DNA is like the mark of Zorro. Single source male DNA from a biological substance that was very inculpatory. That is not what we're talking about in this case. And there's been a lot of loose language here. With Carol Flood, this YSTR result that the state's own expert, and they spent about 5 minutes on this, she said this is a last resort. There was very little discussion about what this is, but it was a mixture of 3 or more people, including 2 males. It was not a mark of Zorro. Also, the scarf business. The only evidence that Lucky Ward gave her this scarf, and that's not even what was said, was Detective Cisneros said that after he turned off the video, Lucky Ward said, let me look at her picture again, and said, maybe I saw her at a homeless shelter, and maybe I touched something. That's what he said. He didn't say I gave her the scarf. This was speculation, and this also is hearsay coming from the detective who admitted, well, he could have turned the recording back on. He'd spent hours recording Lucky Ward, and he didn't. But it's not inculpatory.
But is the giving of the scarf the issue, or is the DNA on the back of the scarf more
And
the issue?
again, Your Honor, it's not a single source male profile. It's a proof that that a male with a Y chromosome cannot exclude Lucky Ward's one chromosome. But there's another male in that mixture, and this is really sketchy stuff that they spent years trying to come up with. It is not beyond a reasonable doubt. And, you know, back to your very smart question, none of this matters if he was incompetent.
I have
And
a question for you along that
Certainly.
line, because I agree with Judge McClure. What does the record reflect to show that there's some evidence at the informal inquiry of the defendant's mental illness?
Your Honor, he first of all tried to commit suicide in the holding cell after he goes into this rant based on his paranoid delusions that the judge is in cahoots with the prosecutors and secret bloggers in the jury box and text messages being sent to them to tell them how to answer. He goes into this rant, and either the state is suggesting that was totally rational, or that's a significant indication the man was not competent. And then he spends most of the trial back in his little jail cell where the judge sends the guards to videotape him. If you look at these videos, you don't see a man who is rationally equipped to engage with counsel or potentially testify. You see a guy out of his mind. And this is why Chapter 46B exists, is so lawyers don't have to try to figure this out. They can get help from professionals. This appointed expert was conflicted. He didn't provide a report. He wasn't even clearly qualified, and he went in over the weekend and they couldn't get Lucky to calm down.
Well, how could you get better? What psychologist are you going to find to treat the person in order to make them competent in order to stand their capital murder trial?
Your Honor, that's an excellent question, and 46B has a lot to say about that. That part of what's supposed to happen is everybody pause, you get the truth, and if you have an incompetent person, there are procedures for restoring competency so that they then can actually be tried in a constitutional proceeding and not something that makes us look like a kangaroo court.
Do you feel like that the defendant's mental illness interfered with his ability to participate in this trial?
Absolutely, Your Honor. And this is not, the defense itself ended up putting on in punishment a mental health expert who described Lucky Ward's long, well-documented serious mental illness of bipolar, schizoaffective disorder, schizophrenia. These include diagnoses made by TDCJ, by the jail, long history going back to his teenage years.
Was he used to establish his incompetency?
No,
Why not?
no, because his lawyers, I can't say, but it looks like they were exhausted. They got a hostile judge who wanted to move forward, said that over and over, and they gave up. It was too difficult to deal with their incompetent client. They just wanted the trial over.
Have you challenged counsel's effectiveness in this appeal?
Your Honor, I have not, because it doesn't tend to be successful in direct appeal, but I suspect that might be something that's coming later. And Your Honor, if I may, one statement about the 404B. I know you're going to do a legal sufficiency review. It is very important not to play fast and loose with what the evidence actually was. Again, the only single full male DNA profile from which Lucky Ward could not be excluded that was introduced by the state was DNA lifted from the passenger door of Charlie Rodriguez's car. And that is completely consistent with what Lucky Ward himself told police about how they had this interaction in a parking lot in Montrose where Rodriguez was going out clubbing and Lucky Ward, homeless guy, was trying to hustle for a tip and said, "I'll watch your car." It's not doctrine of chances. This court's great opinion in Delaz Paz talks about that doctrine. It has to be, again, virtually identical. And again, in that case, you had a buy or bust drug setup situation with a cop where there was no doubt that the guy had done it multiple times. And then in this trial, they wanted to introduce it because, yet again, same pattern. This is not that case. Thank you, Your Honor.
Thank you very much. Case will now be taken under submission.